A baby is born in a hospital in New York City. The parents are not American citizens. They're not permanent residents. They're not even legally in the country. But under current law, that baby automatically becomes an American citizen the moment they take their first breath on U.S. soil. That's been the rule for over 150 years. But in 2026, everything could change. An executive order is being prepared that would end birthright citizenship as we know it, and the implications are absolutely staggering. Welcome to U.S. Visa Info, your trusted source for breaking down complex policy changes that affect millions of lives. Today, we're diving deep into one of the most controversial and consequential immigration policy shifts in American history. The potential end of birthright citizenship in 2026 isn't just another political talking point. It's a fundamental restructuring of who gets to be American and how citizenship is determined. Whether you're an immigrant, a citizen, or someone planning to come to America, this affects you. Stay with us until the end because we're going to explain exactly what's being proposed, who it impacts, what the legal battles will look like, and what you need to do right now to protect yourself and your family. At US Visa Info, we cut through the noise and give you the facts you need to make informed decisions. To understand what's changing, we first need to understand what birthright citizenship actually is and where it comes from. The 14th Amendment to the United States Constitution, ratified in 1868, right after the Civil War, contains a simple but powerful sentence. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This was primarily designed to ensure that formerly enslaved people and their children would be recognized as full citizens, overturning the infamous Dred Scott decision that had denied citizenship to Black Americans. But the language was broad, and for over a century and a half it has been interpreted to mean that virtually anyone born on U.S. soil automatically becomes a citizen, regardless of their parents' immigration status. This principle, known as jus soli or right of the soil, has made the United States one of the most accessible countries in the world for acquiring citizenship. The practical impact of birthright citizenship has been enormous. Millions of children born to immigrant parents, including those without legal status, have grown up as American citizens with all the rights and privileges that entails. They can vote, hold public office, travel with a U.S. passport, and never face deportation. They have access to federal benefits, financial aid for education, and the full protection of American law. For many immigrant families, having a child born in the United States represents hope, security, and a pathway to stability. Critics, however, argue that birthright citizenship creates perverse incentives. They claim it encourages what they call birth tourism, where pregnant women from other countries travel to the United States specifically to give birth so their child will have American citizenship. They also argue that it rewards illegal immigration as parents who enter or remain in the country unlawfully can have children who are automatically citizens, creating what some call anchor babies, though that term is considered offensive by many. The proposed changes for 2026 would fundamentally alter this system. According to leaked drafts and public statements from administration officials, the new policy would restrict automatic citizenship at birth to children who have at least one parent who is either a U.S. citizen or a lawful permanent resident, meaning a green card holder. Children born to parents who are in the country on temporary visas, such as tourist visas, student visas, or work visas, would not automatically receive citizenship. Neither would children born to parents who are undocumented or in the country illegally. The policy would also potentially exclude children born to parents with certain types of legal status, such as those on asylum applications that haven't been approved, or those with temporary protected status. The implementation timeline appears to target early 2026, likely through an executive order that would direct federal agencies, particularly the State Department and Department of Homeland Security, to change how they issue birth certificates, passports, and other citizenship documents. Hospitals and state vital records offices would receive new guidance on what documentation parents must provide to establish their child's eligibility for citizenship. Social Security Administration procedures would change to reflect the new requirements. The impacts would be immediate for any child born after the effective date of the order. Let's break down specifically who would be affected. First, and most obviously, children born to undocumented immigrants. There are an estimated 11 million undocumented immigrants living in the United States, and approximately 250,000 babies are born to undocumented parents each year. Under the new rules, none of these children would be automatic citizens. Instead, they would have the same immigration status as their parents, meaning they would be undocumented from birth. They could face deportation at any time, would not be eligible for most federal benefits, could not legally work when they grow up without obtaining authorization, and would face all the uncertainties and dangers that come with being undocumented. Second, children born to parents on temporary visas would lose automatic citizenship. This includes parents who are in the United States on student visas. There are over 1 million international students in the U.S. at any given time. It includes parents on H-1B work visas, highly skilled workers in technology, medicine, engineering, and other fields. It includes parents on tourist visas, whether they're genuinely visiting or engaged in what critics call birth tourism. Even parents who are legally present, following all the rules, paying taxes, and contributing to American society would find that their American-born children are not American citizens. These children would instead have derivative status based on their parents' visas, meaning if the parents' visas expire or are revoked, the children would have to leave too. Third, and this is where it gets particularly complicated, children born to parents whose immigration status is in limbo. Someone who has applied for asylum but hasn't received a final decision. That process can take years. Someone who has temporary protected status because their home country is experiencing war or natural disaster. Someone who has DACA, deferred action for childhood arrivals, which gives work authorization, but isn't a pathway to permanent residency. The proposed rules could leave children born to these parents in a legal gray zone, neither clearly citizens nor clearly undocumented, potentially creating a whole new category of people with uncertain status. Fourth, and this might surprise some people, there are scenarios where children born to U.S. citizens abroad could also face new complications. While the changes primarily target children born in the U.S., there are related proposals to tighten the rules for citizenship transmission from parent to child when birth happens outside the country. Currently, a U.S. citizen who has lived in the United States for certain periods can pass citizenship to their children born abroad. Some proposals would make these requirements stricter, potentially leaving some children of American citizens stateless or forcing families to go through lengthy naturalization processes. The legal battles over this will be absolutely ferocious. Constitutional scholars are deeply divided. Supporters of the change argue that the phrase "and subject to the jurisdiction thereof" in the 14th Amendment provides an opening. They claim that this phrase was meant to exclude certain categories of people, originally Native Americans, who were members of tribes and foreign diplomats who have diplomatic immunity from birthright citizenship. They argue that this exception can be expanded to include children of people who are not legally present in the country or who are here temporarily. They point to statements from some of the 14th Amendment's framers, suggesting they didn't intend for it to apply to everyone born on U.S. soil. They argue that many other developed countries don't have birthright citizenship, including most European nations, Australia, and New Zealand, and America should align with international norms. Opponents argue that this interpretation is completely wrong and that the executive branch doesn't have the authority to reinterpret the Constitution by executive order. They point to an 1898 Supreme Court case, United States versus Wong Kim Ark, which held that a child born in the United States to Chinese immigrant parents was a citizen despite a law that prohibited Chinese immigrants from naturalizing. The court said the 14th Amendment's language was clear and broad. They argue that subject to the jurisdiction thereof simply means not being a foreign diplomat or invading soldier, and everyone else born on U.S. soil is a citizen, period. They contend that changing this would require a constitutional amendment which needs 2 or 3 of both houses of Congress and ratification by 3 or 4 of the states, not just an executive order. They warned that eliminating birthright citizenship would create a permanent underclass of stateless people, children who are born and raised in America but have no legal status anywhere. The immediate legal response would be swift. Civil rights organizations, immigration advocacy groups, and affected families would file lawsuits within hours of any executive order being signed. They would seek injunctions to block implementation while the cases work through the courts. The cases would almost certainly end up at the Supreme Court, and the decision would be one of the most consequential in generations. The current composition of the court with its conservative majority makes the outcome uncertain. Some conservative justices have expressed openness to reconsidering birthright citizenship, while others have indicated they believe precedent is clear. The case could take years to fully resolve, during which time there would be massive uncertainty about the status of children born during the litigation period. Beyond the legal questions, the practical and human impacts would be staggering. Hospitals and doctors would be thrust into an impossible position. Would they be required to verify parents' immigration status before issuing birth certificates? Would they become de facto immigration enforcers in the delivery room? Many healthcare providers are deeply uncomfortable with this prospect, arguing it would deter pregnant women from seeking prenatal care and could lead to worse health outcomes for mothers and babies. State and local governments would face enormous administrative challenges. Birth certificate procedures vary by state, and imposing federal immigration verification requirements would require massive coordination and training. Many states, particularly those with Democratic leadership, have already indicated they would refuse to comply with such requirements, setting up potential conflicts between federal and state authority. Schools would face unprecedented challenges. Currently, all children in the United States have a right to public education, regardless of immigration status, a principle established by the Supreme Court in the 1982 case Plyer v. Ferguson. But if children are born in the U.S. and are not citizens and their parents are undocumented or on temporary visas, schools will have more children with uncertain long-term status. What happens when these children graduate high school but can't legally work or go to college because they're not citizens and don't have work authorization? What happens to their sense of identity and belonging if they grow up American in every way except on paper? The economic implications are also significant. Children who are not citizens would not be eligible for federal benefits, including Medicaid, in most circumstances, food stamps, and other safety net programs. States and local governments would face pressure to provide services, potentially straining their budgets. If these children can't legally work when they reach adulthood, they would be pushed into the underground economy, which has negative effects for workers, employers, and government revenue. Some economic studies suggest that birthright citizenship actually benefits the economy by ensuring that people born and raised in the United States can fully participate in the workforce and contribute through taxes. Eliminating it could reduce economic dynamism and growth. The international implications shouldn't be ignored either. If children born in the United States to foreign parents are not American citizens, what citizenship do they have? In theory, they should have the citizenship of their parents' home country, but not all countries grant citizenship to children born abroad to their citizens. Some countries require that the child be born in that country, or that the parents register the birth with that country's embassy within strict time limits. There is a real possibility that some children could end up stateless, having no citizenship anywhere. International law considers statelessness a serious human rights violation, and the United States has generally worked to reduce statelessness globally. Creating potentially hundreds of thousands of stateless children would be a dramatic reversal of that commitment. What should you do if this affects you or your family? First, document everything. If you're pregnant and in the United States or planning to give birth here, gather and preserve all documentation of your immigration status. If you have a visa, keep copies of all your paperwork. If you're a permanent resident, keep your green card secure and make copies. If you're undocumented, this is more complicated, but consider consulting with an immigration attorney about your options. Second, if you have children who were born in the United States before any rule change takes effect, make absolutely certain you have their birth certificates and social security cards in a safe place. Apply for a passport for them if they don't already have one. A passport is the strongest proof of citizenship, and if you already have one issued under current rules, it will be much harder for the government to challenge later. Third, consult with an immigration attorney as soon as possible if you think you might be affected. Immigration law is complex and the rules are changing rapidly. An experienced attorney can assess your specific situation and help you understand your options. Many nonprofit organizations provide free or low-cost immigration legal services, including the American Immigration Lawyers Association, local legal aid societies, and immigrant rights organizations. Don't wait until a crisis happens to seek legal advice. Fourth, Stay informed about legal challenges and policy developments. The situation is extremely fluid, and what's proposed today might be blocked by courts tomorrow. Follow reliable news sources, check updates from immigration advocacy organizations, and don't rely on social media rumors. Fifth, connect with community organizations and support networks. Immigrant communities are strong and resilient, and there are many groups working to protect immigrant families and fight harmful policies. For American citizens who care about this issue, there are actions you can take as well. Contact your representatives in Congress and make your voice heard. While an executive order doesn't require congressional approval, Congress could pass legislation to clarify birthright citizenship or to restrict executive authority in this area. Support organizations that are fighting to protect immigrant rights and prepare for legal battles. Vote for candidates at all levels who share your values on immigration. And critically, push back against dehumanizing rhetoric. When people talk about anchor babies or birth tourism, remind them that we're talking about children, innocent human beings who had no choice in where they were born or what their parents' immigration status is. The historical context here is important to remember. Attempts to restrict who counts as a full member of American society are nothing new. In the past, citizenship and full rights were denied to enslaved people, to Native Americans, to Chinese immigrants, to women in various ways. Each time, America eventually recognized these exclusions as moral failures and expanded the circle of who belongs. Birthright citizenship, guaranteed by the 14th Amendment, was a crucial step in that expansion. It said that if you're born here, you're one of us, regardless of who your parents are or where they came from. That's a powerful and inclusive principle, and abandoning it would be a step backward. Some argue that birthright citizenship is outdated in a globalized world where international travel is easy and immigration pressures are high. They point out that the United States and Canada are unusual among developed nations in having unrestricted birthright citizenship. Most European countries, Japan, Australia, and many others, require that at least one parent be a citizen or permanent resident. They argue that America should modernize its approach to match these countries, but others counter that birthright citizenship is precisely what has made America exceptional. A place where your future isn't determined by who your parents are or where they came from, but by your own efforts and talents. It's core to the American dream. There are also questions about how far these changes could go. If the administration can reinterpret the 14th Amendment to exclude children of undocumented immigrants or visa holders, what other reinterpretations might follow? Could they decide that children born to permanent residents also don't qualify? Could they create tiers of citizenship based on how long parents have been in the country? Constitutional scholars warn about the slippery slope. Once you accept that the executive branch can radically reinterpret constitutional amendments without going through the formal amendment process, you've opened the door to all sorts of mischief. Today it might be immigration. Tomorrow it could be other fundamental rights. The timing of this proposed change is also significant. Immigration has been a central political issue for years, and hardline positions have gained traction. There's a calculation that this move would energize a political base that wants stricter immigration enforcement. But there's also a calculation on the other side that this could energize opponents who see it as cruel, unconstitutional, and fundamentally un-American. The 2026 timing suggests this could become a major issue in upcoming elections, with both sides using it to mobilize their supporters. It's also worth considering the personal stories behind the statistics. Every one of those 250,000 children born each year to undocumented parents is a real person. They're kids who go to American schools, play American sports, speak English as their primary language, grow up with American friends and American culture. Under current law, they're Americans. Under proposed changes, they would be deportable to countries they've never known, where they don't speak the language, where they have no connections. The same is true for children born to parents on work visas or student visas who intended to stay temporarily, but whose children have only known America as home. These aren't abstract policy questions. They're questions about real children's lives and futures. The enforcement mechanism for these new rules would also be crucial and potentially troubling. How would the government identify children who are born in the U.S. but not citizens under the new rules? Would there be immigration raids at hospitals? Would parents be required to show proof of their immigration status to get birth certificates? Would schools be required to verify children's citizenship status? Each of these scenarios raises serious civil liberties concerns. We've seen in the past that when immigration enforcement becomes aggressive, U.S. citizens, particularly those who look or sound foreign, can get swept up and have their citizenship questioned. Making citizenship at birth conditional rather than automatic could make this problem much worse. Looking at international examples of what happens when birthright citizenship is restricted provides some lessons. The Dominican Republic eliminated birthright citizenship for children of Haitian immigrants in 2013, retroactively stripping citizenship from people who had been born there and lived there their entire lives. The result was a humanitarian crisis with hundreds of thousands of people suddenly rendered stateless, unable to work legally, attend school, or access basic services. Many were deported to Haiti, a country they had never lived in, and where they had no support network. The international community condemned this as a human rights violation. While the U.S. situation wouldn't be identical, there are warnings here about what can happen when birthright citizenship is eliminated, particularly if done retroactively, or if there's no clear alternative pathway to status for affected children. In conclusion, the potential end of birthright citizenship in 2026 represents one of the most dramatic shifts in American immigration policy in modern history. It would affect hundreds of thousands of children each year, create legal chaos and uncertainty for years, generate massive constitutional battles that will ultimately be decided by the Supreme Court, and fundamentally change what it means to be American. Whether you support or oppose this change, there's no denying its significance. For those who would be directly affected, the stakes couldn't be higher. For all Americans, this is a moment to pay attention, to understand what's being proposed, and to make informed decisions about what kind of country we want to be. At US Visa Info, we'll continue following this story closely, bringing you updates as the situation develops, explaining the legal battles as they unfold, and helping you understand what it means for you and your family. Here at US Visa Info, we're committed to breaking down complex policy issues so you can make informed decisions. If you found this information valuable, please share it with anyone who might be affected by these proposed changes. Subscribe to our channel and hit the notification bell so you don't miss our continuing coverage of this critical issue. Leave your questions and thoughts in the comments. We read every single one, and we'll address as many as we can in future videos. The more people who understand what's at stake, the better equipped we all are to navigate these challenging times. Thank you for watching US Visa Info. Stay informed, stay engaged, and remember that knowledge is power when your future is on the line. We'll see you in the next